The Nuclear Talent Show is a long-format interview. NuclearTalentBoost.com contains straight-to-the-point lessons that we don't include in the show. We have forums and discussion spaces where you can ask questions to colleagues to help with your current job and get credit from our clients for your participation in a way that shoots you to the front of interview lines. All this and more for free in exchange for your resume and job preferences, which allows us to save your time by only reaching out to you about states, rates, and dates that fit your desires, unlike so many other recruiters. We can place you directly in-house with our clients or as a staff aug contractor. You sharing this video with your colleagues helps them obtain life-changing jobs and helps us keep making this amazing content. So please repost and share our videos. My old friend Andrew.Kriha is a very unique talent who spent years as a reactor engineer before becoming a lawyer. His work interfacing with the NRC, EPA, and other federal agencies gives him a unique insight into recent congressional acts and Supreme Court rulings that will help you and your company take advantage of this new springtime for nuclear law. You're a lawyer and follow all these different federal agencies and rulemakings. How do you switch between following the EPA and following the FTC and all these other groups?
Yeah, I mean, so there's common elements, right? Especially from the legal side, where a lot of the advice that I provide is, a lot of it is compliance with specific regulations where you need to understand the industry, you need to understand the industry specific terminology. But a lot of it is just the agency process in general. How are the courts going to view this type of agency action? And that is pretty common across agencies, right? That's all pretty much governed by the Administrative Procedure Act, or APA, and it's evaluated according to the same standards, the same universe of case law that we're going to be talking about. So there are common themes that make it somewhat tolerable and easy to do all of these different things. And I like to have a diverse portfolio. I don't want my entire practice to collapse if nuclear falls out of favor again for no apparent reason. And that keeps things interesting, right?
So there's various different industries that utilize the APA and various different industries that use the Federal Register. Compared to other industries that you work in, Andy, what's the difference with working with the NRC? Is it just a matter of the NRC's regulations and rules are just so voluminous? Is the NRC ridiculously out of control compared to other federal agencies? Is that just like a myth, or is it really producing that large of a volume of rules and all this stuff?
I would not say that the NRC is disproportionate to other agencies, at least, controlling for the scope of agency action. The NRC does have to act more through individual adjudications than other agencies. There's just so many actions going on every single day that directly impact safety. They have a little bit broader of a mandate. But it is true, I guess, to a little extent, right? The Atomic Energy Act is a much broader statute than the statutes that other agencies operate under. And when I say broader, I mean just more broader in terms of how it's written, in terms of granting the agency discretion. In terms of licenses, the Atomic Energy Act doesn't go much beyond just saying every plant must obtain a license, and the NRC will grant a license in accordance with the goals of this act. Whereas a lot of other statutes for, say the EPA or someone else will be very specific and say you have to grant a water permit, and to grant a water permit, it has to be based on the best available technology, and these are the procedures you have to use to determine what the best available technology is. And so there's, much less discretion. In that way, certainly it does lend itself to the NRC sometimes feeling like there's a little bit more of a whack-a-mole going on.
Yeah, I believe that. That sort of transitions nicely into all these different Chevron conversations that we want to have, right? Because the Atomic Energy Act was somewhat ambiguous and vague in terms of like what it wants the NRC, and the Reorganization Act that birthed the NRC. Both of these legislations, they're relatively ambiguous in what it wants the NRC to do and what exactly they should do. And with Chevron, the general law of the land was, hey, we don't want some random lawyer making decisions
about all these super technical issues. We want super technical people at these federal agencies. They'll be able to make decisions way better. So in general, defer to their judgment. And so you had the agency itself essentially being its own judge deferred to. But now Chevron is dead, or Chevron deference is dead, or at least that's my layman's ears. Maybe that's just headlines talking, but now there's this new brave new world. So please talk about that.
Yeah, I mean, there's a lot going on in this area, which we would refer to as administrative law, right? The law of agencies. It is, for the past few years and continuing, for the foreseeable future, rapidly changing in ways we haven't seen in several decades, being reshaped by this current iteration of the Supreme Court. Let me start by explaining what Chevron deference is.
All right, do it, because I didn't do it right.
Well, you did a good job. You did a good job of explaining Chevron, but let me explain it within this context of administrative law, right? So It said specifically where a statute is ambiguous as to, what its direction is to the agency, the court still got to define what the universe of reasonable interpretations were. And as long as the agency's interpretation fell within that reasonable universe, even if the court would have said, well, I think a different interpretation is actually a little bit closer to what I think Congress meant, we're still going to defer to the agency and what they say. And the reason for that, as you said, was because of their technical expertise. There was a heavily related doctrine called Auer deference, or sometimes referred to as Seminole Rock deference, both after case names. All of these are after case names. It's kind of weird how it develops that way. But Auer/Seminole Rock deference was the exact same thing, but for regulations, right? If an agency wrote an ambiguous regulation, then the agency got deference in terms of, as long as the agency's interpretation of its own ambiguous regulation is reasonable, we're going to defer to what they say, even if the court thinks, well, actually, the way it's written, I would actually interpret it this way and think it's reasonable that a company would have interpreted it that way if you're now trying to enforce something against them. This exists in a broader context where the court is also going after overbroad statutes. So the court has kind of taken a position that Congress doesn't have authority, that Congress is the sole legislative policy-making branch. It cannot delegate the ability to make policy to executive agencies. That popped up fairly recently to a kind of constrained extent in a case called West Virginia versus EPA that was decided by the Supreme Court about 2 years ago. They refer to that as the major questions doctrine. And that basically says if there's a statute that is written extremely broad, then even if what the agency is doing is within that, right? So in that case, the EPA had to select the best system for reducing emissions. And the EPA said that a system of reducing emissions is to shut down coal plants and divert that to natural gas, solar, renewables. The court said, well, yes, that fits within a common definition of system. By the plain language, you have authority to do that, but we're going to constrain you, agency, by saying that doesn't really fit with the history. This is a new authority that you're purporting to exercise. You have always previously interpreted that to be an on-site, right, some sort of a technological control that can be put on. A system is, a scrubber. It's not shutting down a plant and building a new one of a different type. And when these cases are about, something of great political significance that we think Congress would want to weigh in on, like the type of energy that we make, we're not going to let EPA decide that. We're not going to let NRC decide that, any agency. Congress has to decide that. There is a much broader concept called the non-delegation doctrine that is being litigated in courts right now. The Supreme Court just turned down 2 opportunities to bring that back, to expand on that doctrine, but it seems likely that when they get a case they really like in the next couple years, they'll bring that back. And that's going to say, if they bring it back, that any agency discretion, with a few very limited exceptions, any agency discretion to do anything that looks like policy isn't going to be allowed. So coming back to Chevron and Auer, those were both recently constrained. Auer deference by a 2019 case called Kaiser v. Wilkie, where the court said, you can't write an ambiguous regulation and then just do whatever you want with it, right? And interpret it any way you want want to interpret it, you have to be reasonably clear. Courts are very good, right? Judges, lawyers, what they train their entire careers for is to parse language and interpret language. And we think we can get to a good answer. And if we get to a good answer, you agency are going to have a pretty compelling reason why your interpretation is better than ours in order for us to defer to you. Otherwise, we're going to do everything we can to reach our own independent conclusion before even thinking about what you agencies say about how your regulation should be interpreted. Chevron went largely the same route. It was framed a little bit differently. That was a very recent case just about a month ago called Loper-Bright. They framed it as a complete overturning of the Chevron doctrine versus they did not frame Kaiser as an overturning of our, just as kind of a restriction. But at the end of the day, what they're doing is they're taking it to roughly the same place. They've re-implemented something called Skidmore deference, another case name from a very long time ago, that says largely the same thing, but for statutes instead of regulations. So where we are now on agencies interpreting statutes is same thing, right? The court is going to look and say, we're going to do everything we can to come up with the best possible interpretation that we can come up with just based on the words in the statute. Depending on the judge, maybe we'll look at, some statements some congressman made around the time of its passage to indicate its intent. But we're not going to take into consideration what the agency says or what the agency thinks it should mean unless we really can't get to an answer or it's still really ambiguous at the end of the day. We think maybe there's 2 or 3 good answers, and then maybe the agency can be persuasive, but the agency is not determinative. And so the thing we're going to have to look at going forward, how this all kind of fits together, is we don't know yet where a court is going to say, oh, this statute is ambiguous versus this statute is overbroad, right? So when we talk about the Atomic Energy Act and the reorganization, is it worded ambiguously where, anything can be subject to 2 or 3 different interpretations, and so we're supposed to defer or not defer to how the agency would interpret that language? Or do we think it's just far too broad and based on its breadth, it's an unconstitutional delegation of policymaking authority, whether or not we agree with the agency or have our own good interpretation of what the language actually means? And so I think you're going to see a lot of court cases, where the plaintiff is going to bring both arguments and then see which one the court decides to run with. And it's going to take years to sort that out. And there's, nuanced different implications for which one the court runs with. 2 other quick things. I know I've already droned on for a very long time about this. A few other considerations is, one, in this particular context, how far do we think the court is going to take that? So we have seen in some other contexts where the courts have just realized how technically incapable they are and decided to deviate from the broader rules that apply to agencies generally. This is extremely common in the national security context. So if an agency action claims to implicate national security, we have seen some just outright wrong decisions that everyone, every side of the aisle would say that's not what the statute says at all. But the court is like, it's the executive's job to do national security. We don't know national security. We don't want to accidentally screw up national security. So we're just going to reach this conclusion that says the executive branch can do what it wants to do. So when we start to get into issues of nuclear safety, which, the higher courts haven't grappled with all that much over the years, there have been a few cases here and there that have mattered. But if it comes down to a licensing, some sort of a licensing decision or something like that, is the court going to follow this new broader anti-agency stance that it's staked out, or is it going to restrict itself a little bit and say maybe the NRC knows a little bit more about this than we do, and we're going to come up with some reason why it's okay to defer to the NRC even though we don't defer to other agencies in similar contexts?
I mean, the recent headlines for the last month or 2 has been, like the ANS newsletter things, just that industry urging Supreme Court to hear interim waste storage facility case, where they got I forget if it's New Mexico or wherever, the NRC issued a license for this large consolidated dry cask storage facility, and then I forget which court just said, no, you didn't have the authority to do that. And so now people are just sitting around without a license and wanting to get the Supreme Court to come in and save their project or something.
Yeah, and that's going to be one of these first instances, and that's a whole nother route that we could do an entire podcast or 2 entire lessons on. I believe that's in Texas, which means it goes up through the 5th Circuit Court of Appeals, and entire case studies just on how the Fifth Circuit acts. It's going to be something to watch. The other thing I was going to say, a Supreme Court decision from about a month ago that flew way under the radar but is going to have massive implications is this case Corner Post, which effectively made the statute of limitations to challenge rulemakings under the APA limitless. There is a 6-year statute of limitations that has always been interpreted to be 6 years from the time of a rulemaking, and the Supreme Court said, no, it's 6 years from the time that whatever party is suing was harmed. And so if a new company is formed, their 6-year clock starts from the time they were formed for any rule that impacts them. And so we have all these new, right? It seems like every day there's a new advanced reactor startup. They can go back and start challenging these NRC rules that have been in place for 30 years if they want to, things that have been settled for a very long time. And so we're going to start to see a flood of litigation across agencies challenging anything anybody doesn't like. And so that's really going to open up a lot of new litigation, I think.
Yeah, I know this isn't like quite a perfect analogy, but in my own family and probably anyone else's family of origin that they grew up in, there's always the mom said no, so I'm going to go ask dad. And then I guess the dynamic for the last, however many decades with Chevron has been a dad always sides with mom. Don't even bother asking dad.
Yeah.
And now, and that's sort of been the mentality. It's just like, well, NRC is going to come down on some rule. The OGC, the Office of the General Counsel there, they've just got so much consolidated, essentially liberty and decision-making authority there that practically can't be challenged because they're the ones that sort of interpret the NRC's rules. And, if I, as an applicant, there's some aspect of my new reactor design that I think the regulations say is fine, but then the OGC or NRC in general says, no, like it's not fine. That's not what the regulation means. And you need to add in 5 extra valves instead of having 1 there or whatever it is.
Yeah.
It's like you just sort of sat there and took it, right? Because it's just like, well, what am I going to do? Take him to court? The court's just going to say, Chevron deference, baby. Like, NRC knows what it's doing. We're not going to question it. So, whereas now it's like, is this going to totally change the attitude of how applicants march through the NRC's processes, knowing that they can, like, actually have real challenges? Like, this is an exciting thought experiment to me, and I guess we'll see how it plays out soon. But in the signs of these optimistic nuclear times, maybe I'm just running with headlines, and Russell, this isn't actually what it means, and you're still going to have to just sit there and take it. What's this mean?
Well, I'll give one real example that happened. Obviously, I'm a lawyer, right? A lot of what I do is confidential. I have to talk about it in pretty broad terms. But a large enforcement action that I defended, the company was accused of a handful of different violations. One of those was Part 21, failing to meet a 5-day deadline to make notifications under Part 21.
And Part 21, for those who don't know, it's the reporting of defects. And so in the same way that the National Highway and Safety Administration, you'll get a recall notice about your car, like its brakes are broken and you need to get it in for a repair ASAP. There are other industries that have these reporting of defects to make sure that customers know that you accidentally let a bad batch out of your factory or whatever. And 10 CFR 21 is essentially that for nuclear.
Yeah, exactly. That's a perfect analogy. And so what happened here was there was an incident that occurred that arguably could have mandated some Part 21 reporting. The NRC regulation is extraordinarily ambiguous on this timeline. It says you must make your notifications within 5 days of determining that it is an issue. The company determined that it wasn't an issue, that it didn't, or, it was an issue, but it didn't rise to the level of requiring a Part 21 notification. And the NRC, sometime later, as part of an inspection, looked at that analysis, disagreed, and then said, you missed your 5-day reporting deadline because you discovered it 9 months ago and never took any action. And, my argument was you're interpreting your own regulation wrong. It's 5 days from the date we decide that it's an issue. The regulation puts an onus on us to make a decision that it is an issue. It doesn't put that onus on the NRC, and it doesn't give us a deadline to make that determination. Now, you can argue that that's wrong, that there should be a regulation that says you only have 30 days to make this determination or whatever, or the NRC can step in and make the decision for you if they don't like the conclusion you reached. But that's not how it's actually written. It's written that the entity that has the issue has the sole discretion to determine if it requires Part 21 reporting. Then they get 5 days from that determination. And since we never decided it was an issue, we never had an obligation to report. And when I did that, I brought up these recent cases that were ongoing. I brought up Kaiser, which was the applicable case directly, but then I also brought up, the ongoing cases of Chevron, where the court's heading, how it's likely to be interpreted. And, we were able to reach a resolution that all parties were happy with, but that was probably more favorable to the client than would have been in the past, where we didn't have this kind of new era of decisions coming down. I think the other interesting thing to watch going forward that I'm going to be fascinated by is with the Advance Act putting into the NRC's mission statement that its decisions in terms of licensing, et cetera, shall not interfere with the growth of the nuclear industry, or I'm probably miswording that slightly, but that's the gist of it, right? That's going to be fascinating to watch, I think, because now you could get people whose licenses are denied, or not even denied, just delayed, right? People frustrated with the amount of time it's taking the NRC to make a decision, suing and saying you're interfering with the growth of the industry in the way that you're carrying out your licensing activities, NRC, and that's contrary to your mission statement. And if it were any more specific of a statute, something like the Clean Water Act or the Clean Air Act that I referenced before, that have these very specific procedures for making all these determinations, a court would tend to be like, well, the mission statement is just kind of a general statement of purpose. It's not an actionable thing. It can't interfere with more specific instructions that are given in the statute. So if the statute said, NRC, you have to specifically consider these things and go through this specific process when you're issuing a license, maybe that mission statement doesn't matter. But since we have a much broader statute here that doesn't give a lot of direction, that just kind of relies on the general purpose of the statute and says NRC issue licenses in accordance with the purpose of the statute, and one of the purposes of the statute is now don't interfere, don't inhibit growth of the industry, how courts handle that. And then also in the context of what I just talked about, of maybe this is an area where they're going to self-restrain themselves a little bit because they don't want to screw up a big nuclear decision and then get blamed for an accident. I don't know how that's going to play out in the courts, but all of these kind of things we've been talking about are all going to come to a head in this one little very impactful area for the industry. So it's going to be a fun thing for all of us to be a part of, and a fun thing to watch going forward.
I love that 10 CFR Part 21 story that you just gave. I have been on several, do we have to do a Part 21 or not? Like, when do we need to do this by? And then 3 different licensing engineers give you 5 different answers. And then the 2 company lawyers disagree too. And it's just wait, it can just get so confusing, and people can feel like the stakes are so high that you're going to have to do a Part 21. No, I think that for Part 21 especially, but for lots of other things too, it's just such a value-added thing to have a lawyer who is also a nuclear engineer, right? Is there a difference between a rule and a regulation?
They're used interchangeably. There are different types of rules/regulations. There's substantive rules, there's interpretive rules. So they require different levels of review. There's different standards in terms of whether a court would find something to be binding on a party, and if it is binding on a party, what that level of procedure they have to go through, how many hearings, how much comment period, things of that nature. There is guidance that is purely guidance that's not binding, that is formalized in the CFR. It's rare. It's a little odd. Typically what you see in the CFR is binding upon parties, but there are instances where it's not, and all of that has to go through less procedure. When you think of a substantive rule, and this is simplifying it a lot, but for this audience, when you think of something as a substantive rule, that is something that has binding effect on parties, that creates some sort of an obligation for the regulated party to meet, that is generally going to require a longer, more detailed process for the agency to issue that rule. It's going to require the agency to accept comments from the public for a longer period of time. It's going to require the agency to consider every one of those comments and rationalize why it did or did not accept the premise of those comments. In some cases, could require hearings where people can give oral comment, things like that. And so that's kind of the trade-off to create a binding obligation. Guidance is not going to create a binding obligation. There's less procedure that it has to go through. The agency doesn't have to consider necessarily, depending on the exact situation, comments from the public before issuing it. But then if the agency uses that as a basis to enforce a violation against somebody, the court is going to take a much more skeptical view to what the agency did and whether or not there was an obligation for the party there or whether the agency is interpreting it properly.
So there's the actual 10 CFR, right? Those are the actual regulations. By definition, the 10 CFR regulations are the minimum requirement that the commission has found necessary to provide reasonable assurance of adequate protection of the public from radiation. Anytime that you see a 10 CFR, that just is the law. And unless you can prove that the law itself says it's not applicable to you, or unless you get an exemption from the law, as silly as it might sound, that like this couldn't possibly be what the US government thinks is the minimum requirement for me to ensure the safety of the public, because this seems like so distant and removed, and there's just no way in hell this valve failing or not failing is going to actually affect anyone. But like, it's the law that like this is just the absolute minimum that we require to achieve the reasonable assurance of adequate protection, which is some language from the Atomic Energy Act itself. Yeah, do you want to expound on that at all?
I don't know how much there is to expound on that. I think you kind of hit the nail on the head. The other thing is, right, this does come into play with everything else we've talked about today in terms of, well, now this is the law, this is what is binding for you to meet by the NRC standards, but maybe there is an opening now if you think this can't possibly be, this doesn't have any impact on safety, to say, well, did the NRC validly promulgate this regulation? Does the Atomic Energy Act, as amended throughout the years, actually give them the authority to do this? Does the Constitution give them the authority to do this via that statute? And, you know, potentially challenge some of that thinking. But the lesson for an engineer, right, because the engineer is not going to be the one making that decision, right? The lesson for the engineer is, yes, that is the law of the land. That's what you have to do. And that's, like you said, the minimum standard. The NRC could determine in certain circumstances that a higher standard needs to be met. A lot of that is defined through their various guidance documents and types of guidance documents, and even some NEI documents that have been incorporated into guidance by reference. So it's a little bit of a patchwork, right, of different sources of information that you have to kind of collate to come to the right answer. But yes, in general, until a court says otherwise, until you convince your lawyer to go after the NRC and change the rule, that is the rule and that is what you have to comply with.
The Advance Act, was that actually changing some words in the Atomic Energy Act? What's that actually doing? What's the deal with that?
Yeah, so that does amend the USC as it currently stands. It moves certain provisions around, adds in new ones. So there are sections on export controls, something I was just working on. It directs the DOE and NRC to come up with a framework to be able to provide for general authorizations for countries that don't necessarily have 123 acts. 123 acts being kind of shorthand for nuclear cooperation agreements with other countries. So that should cut down on the time it takes in order to export to some of these countries that previously required an application for a specific authorization that can take a significant amount of time. Also, while generally making it easier to do exports to friendly countries, does have some provisions that make it tougher to import from and export to China and Russia. So it modernizes the rules regarding foreign investment. So again, from friendly foreign countries, they are not going to be restricted to being minority owners of nuclear facilities here in the U.S., which we've seen in the past, several companies come right up to that line, 49.9% ownership. And who knows if it would have been better or worse had they been majority owners. I don't know. But they've made a determination that certain friendly countries do not pose a national security risk. There's some various provisions in there to try to beef up our supply chain and promote advanced reactors. So easing the licensing pathway to advanced reactors, to production of accident-tolerant fuels, things like that. There's a few DOE funding opportunities, awards given to the first plant or first facility to achieve different milestones, such as first to use accident-tolerant fuel, things like that, and just generally directs the NRC to consider the impact to the industry when going through its licensing processes and to not unnecessarily inhibit growth of the industry through its licensing process. And there's also some stuff about fees and fee structures and how it charges fees for applicants and licensees. I think that's
Nice.
Everything. Maybe not.
Yeah.
There's a lot in there.
No.
It's a big bill.
I would love to hear you talk through if you're just like right on it. The fact that only NRC actions are subject to judicial review from federal courts. And so NRC does a lot of things that aren't actions, right?
Oh, yeah.
And they'll just tiptoe around and like try to like purposely not do actions as much as they can. But yeah, like where is the line between like what is an action versus what is whatever else they call it when they do stuff?
So that's actually just kind of a hallmark of administrative law generally.
Register for free at nucleartalentboost.com to hear Andy's lesson on regulatory actions and their legal implications for your reactor, so you can finally understand the NRC easily.
Yeah, I like that case-by-case basis stuff. It just reminds me that while most federal agencies flow out of the APA and an associated congressional mandate and follow some sort of rulemaking process via the Federal Register, etc., it's neat to note that, how differently different agencies act, right? Some agencies, they really want to throw their weight around all the time. And so, it's like, hey, I'm not going to get challenged until like years later, and maybe this will help me advance my agency's agenda, whatever that may be. And so they'll just take on a bit of a world of their own and throw around their weight. But you could have a similar agency that just has someone a little more dialed back, let's say, in the driver's seat of that agency. And, on paper, they've got like similar mandates as the other agency, but for whatever reason, they don't throw their weight around and they don't advance agendas as much and stuff. And so I think that whether you think a federal agency is just totally in bed with the industry and throwing their weight around completely unconstitutionally and oppressing you or whatever, or whether you think that there are these noble heroes that are perfectly following their mandate to protect Joe Public. I guess it sort of like depends on the case at hand and depends on your perspective as a citizen. But certainly with the NRC, you'll get people looking at the NRC with both of these glasses on, right? There's lots of people in the industry who think like the NRC is the one thing holding us back from too cheap to meter. And then you'll have people in the public who think that everyone at the NRC is this super pro-nuclear person that's just sweeping radioactive Simpsons sludge sorts of stuff and three-eyed fish under the rug for us. And I mean, the NRC definitely like fits between those two extremes somewhere. And usually when both parties are looking at you wrong, you're probably actually doing things somewhat close to right. I don't really view NRC as either of those things on the spectrum. I think most people who have been in the industry long enough know that they're like pretty moderate. What do you think, Andy?
Yeah, I mean, obviously I have to choose my words somewhat carefully, but I think that's right. I mean, to the extent the industry thinks it's overregulated, there's plenty of lame to go around, and there's plenty of self-regulation going on, via IMPO, et cetera, that, at least is perceived as necessary in order to keep the NRC from being even more restrictive, but who knows? It's weird. Being on both sides, well, not both sides of it, but being on two different sides of coming at the NRC from two different angles, first as an engineer working in industry and then as a lawyer. I think while working in industry, I think I felt a little bit more of we're overburdened here. There's a certain amount of security theater going on, which is probably true, but I was the one who had to deal with that security theater on a daily basis. So there was a little bit of that, but coming at it from the lawyer side, as someone who has... I haven't done a ton of licensing work. I've done some. I've predominantly, my interactions with them have been enforcement actions, so I've dealt a lot more with the enforcement department. I've found them very reasonable relative to other agencies. They're career staff, right, that you're dealing with for the most part. You're very rarely dealing with the politicals. And there are people who are very committed to their job, believe in the mission, but also understand their role and don't want to, make you do something just to do it. They want to make you do something to be safe, but they don't want to make you do something that isn't going to make it materially safer than, something that's twice as cheap, right? At the end of the day, I'd say I agree with you, right? They're somewhere in the middle. They do their jobs. They have to do their jobs. They have to keep you safe, right? But they're not out there just to screw industry either.
Yeah, I mean, you're definitely safe saying that they're somewhere in between the absolute two extremes. So
I think their default position is if they think you did something wrong, they're going to go for the penalty that they feel is appropriate for that. But they are very persuadable with logic and reason. If you can say, look, these are the mitigating circumstances, they're going to understand that and back off.
There's probably a bunch of people that just heard in the news or what we were talking about earlier that, hey, Chevron deference is dead, and now we can just step on the NRC's neck and make them do what we want, and like stuff like this. And it's like throughout different commissioners and different acts that have been enacted, let's say, it's always still been like, hey, you're an engineer and you're talking to an engineer at the NRC, usually. You're talking about a specific situation, and there's like a certain amount of like respect and cordiality that's going into this. And like no matter what is going on in the Supreme Court or, you know, whatever these different regulations say, at the end of the day, it's like you are explaining why you think something is safe. And some other well-educated engineer is also looking at your widget and saying, yeah, I think you're right. This looks safe. And so, you know, first principles, philosophies, follow the golden rule, don't be a jerk. And like, you know, interactions with the NRC can be good, because I think that there's also another common prejudice that like lots of NRC staff people are just like idiots, and so why should I even like bother to try to talk to them or something. But it's certainly never been the case in my interactions with the staff, and I've interacted with them a lot at different companies. They're usually pretty competent people, and you should imagine that career NRC staff person, his only job has been to, you know, look at motor operated valves. They've been looking at motor operated valves for the last 30 years. They've seen the proprietary version of every single applicant's motor operated valves, right? They pick up a lot. And if they weren't smart before, they sure are smart after that. Yeah, it's just completely silly when I see some people just walk in there that have like casually designed one motor operated valve once and think that they're going to go trample all over this person that doesn't know anything. I was hoping to do like a bit of a compare and contrast of like the Advance Act versus the Nuclear Energy Innovation and Modernization Act of 2019. Do you remember that one? It's the one that like forced the NRC to write 10 CFR Part 53 by like 2028 or something. There's what 10 CFR 53 and the Nuclear Energy Innovation and Modernization Act of 2019, the amount of leeway and life that it gave the nuclear industry. There's the Advance Act of 2024. It says some good things, and I'm sure that those extra words in the Atomic Energy Act are going to be pretty useful at some point. But like Chevron deference going away, it's just off the scales in my opinion in terms of the impact that it's going to have on our day-to-day and the general flourishing of our industry. In my opinion, I don't know, I could be proven wrong when I look back at this recording 2 years from now, but yeah, what are your thoughts on just the impact of these three recent major happenings in nuclear law?
Yeah, I'm gonna slightly disagree with you. I think the two laws are probably going to have the bigger impact just because they give very clear congressional direction to the agency to streamline its process in various specific ways. But it's pretty clear about what it wants them to do in those ways. A little bit more so, if I recall, it's been a while since I've looked at the 2019 law, but I think that was a little bit more specific than the Advance Act. But, you know, Chevron, at a high level, it had been falling out of favor at the Supreme Court for a while. You know, the Supreme Court hadn't relied on Chevron to make a decision since like 2016, and certain lower courts had been moving away from it, kind of taking the hint from the Supreme Court, which had Chevron cases come to it, but kind of decided them on other grounds that chipped away. They were like, oh, we don't want to directly address Chevron. We don't want to overturn Chevron, but you know, we're going to chip away at it by deciding in this narrow way. It was still relied on pretty heavily by the district courts, which are the lowest level of federal court. There were still a lot of decisions being made on Chevron, so there is going to be some impact for sure. But I don't think we can say yet with certainty what that impact is going to be for the NRC. A lot of the things, you know, I know we talked about in preparing for this, you know, the linear no threshold rulemaking, you know, stuff like that. A lot of that is more under Kaiser, under the interpretation of its own regulations, and under just more general theories of administrative law that didn't rely on Chevron, like the reasonableness of agency decisions under the terms of the APA. So I feel like if we were going to get big transformative lawsuits, I'm confused why people didn't already bring them if they thought they were necessary, because I don't think Chevron is as enormous of a step as it's gotten pressed for. And you really need to go through and look on a case-by-case basis. Like, what about the Atomic Energy Act is ambiguous? Like, what is ambiguous versus what is overbroad? It is a very broad law. I think there are opportunities to challenge that, especially I think the Advance Act could fuel some overbreadth challenges now that it's amended the NRC's mission statement. But I don't necessarily know how ambiguous it is. It generally just says things like, to make a power plant, you have to get a license, and the NRC is going to make some regs about licenses. All of those are things that I think already could have been challenged. Maybe people were sitting on their hands thinking Chevron gave them a leg up, so maybe we'll see some action there. I don't know. It all remains to be seen. But, I think the bigger things in administrative law are the non-delegation doctrine, which is probably coming down the road. That's more of that overbreadth challenge, and people could start bringing those challenges. I think it's corner post, which is going to let all of these brand new startups start bringing facial challenges to regulations that have existed for 40 years. That's just going to open up a whole new can of worms. But we'll see. You never know. I think all of them are going to interact with each other, interplay. I think challenges that use Chevron as their basis exist now in the world of the Advance Act and in the world of the 2019 law, and judges are going to interpret it in relation to those laws. So, in that way, they're going to come together to potentially fuel challenges. So I've kind of, my own personal crusade has been kind of tempering the expectations of Chevron. I think that's something that administrative lawyers more generally have been like, hey, it is a big deal. It is a very big deal. But it's maybe been a little bit overhyped by the media to some extent. And so have I gone too far the other way then? I don't know. We'll find out.
Indeed. Well, it should be fun to watch. Yeah, you mentioned the linear no threshold rulemaking, and we'll put a link to it in the show notes. But that was a petition for rulemaking that a few members of the public put in around the year 2015. And I remember when I picked it up in 2015 as a licensing engineer at the time, I read it and I said, oh my, like this could change everything. And then I just didn't hear anything about it for a long time. And usually there's like a whole bunch of different industry documents and, like let's support this sort of a thing. But maybe I was just living under a rock in that time period. I was having kids at that moment. But anyway, recently I realized that in 2021, the rulemaking had gotten denied, and it gave a whole big basis for why. I read it and I was still in shock and disbelief. Like, how could this decision have come down like this? It seemed so airtight. And for the viewers that don't know, the linear no threshold dose effect model is basically the basis for the NRC's radiation protection regulations, which is like, the whole basis of the NRC. And it's essentially saying that, hey, we know over here, if you get 200 rem of dose, you're going to die. We've got that data. And then for 5 millirems of dose, we can't really statistically tell what the heck that does to you as a human. We're just going to assume that you can extrapolate from all these high doses and go down to some millirem of a level of dose and say that any dose, any time is adding to your risk, completely neglecting background radiation and all these other indicators that show that there is some sort of threshold probably that if you stay below, I don't know, this petition for rulemaking brings them up and you can look them up. But, let's say that hey, as long as you stay below 5 or 10 rem over the course of a year or whatever, your risk is really not going up at all. Heck, there might even be a medical benefit to getting low doses of radiation. The rulemaking was essentially saying, hey, we should get rid of the linear no threshold model and incorporate all this new health physics data that has been coming in over the last 6 decades of knowing about radiation. And yeah, it was essentially targeting 10 CFR 20, and it was going to greatly increase the amount of risk and the amount of dose that we as a nation, I guess, through this rulemaking, we're going to say was okay and tolerable levels of risk, right? That nuclear is special, but it's not that special. And we could maybe dial it back a bit and tolerate a little more risk here and there. But yeah, anyway, then it got denied. Go ahead, Andy.
Well, so this is a perfect example of where Chevron is not going to impact the industry. This is a perfect example of where there's been some misinterpretation about how courts treat agency expertise, or at least an agency's purported expertise, if you don't agree the LNT. Chevron is just about interpreting statutory language. So it's about interpreting that language we talked about earlier that's in the USC, which agencies typically do via rulemakings, the stuff they put in the ECFR. When the agency puts that in to the ECFR and they're citing their authority, what Chevron hits is if the statute is ambiguous. If the statute gave some sort of a command to the NRC to, say, regulate radioactive safety. I don't remember exactly what's in the statute, but say it's a broad command or an ambiguous command that says regulate radioactive safety. And the NRC says dose controls are radioactive safety. We need to make a regulation about dose control. And you disagreed. You said dose control has nothing to do with radioactive safety. That's an entirely different concept that doesn't fall within the definition of radioactive safety. They're misinterpreting the statute. That's where Chevron would play in. That's where the court would no longer defer to the agency and would consider alternative interpretations of what radioactive safety means. Obviously, this is a terrible example because obviously dose control falls within radioactive safety. That's not an ambiguous term with respect to that. But play with me for a second, right? That is where Chevron would come into play, but that's not what's being debated here, right? The NRC has clear authority to regulate dosage limits in some way, but they are doing it in what many in the industry have alleged to be an arbitrary way, by arbitrarily saying that the linear no threshold theory is the standard barrier.
Is real.
Is real, right? Is the standard barrier.
We can't definitively prove that it is real, but just to be safe.
Yeah.
Because you can't definitively prove the other way.
So that is an APA issue, and the APA has an incredibly low bar. The APA just says that the regulation has to be reasonable and has to have been reasonably explained by the agency. So if the agency provides an explanation that says, we think it's the most conservative, we reviewed the data that was provided about low dose, and we just don't think it's conclusive, we think it's still better to play it safe, that's an explanation that the court is still going to defer to. They're still going to say, you know what, yep, you're the agency. We don't know what is safe and what isn't safe. You do know that, and you have provided, you've met your very low threshold of explaining why we should defer to you here, so we're still going to defer to you here. Chevron doesn't change that. So Chevron doesn't suddenly give us an out to get rid of the linear no threshold theory.
My heart is broken.
That's literally the perfect example of where agency expertise is still going to come into play. Now, if we wanted to go down this path, I can tell us my own personal opinions on the linear no threshold theory and some examples from work. I tend to think, I've looked at the evidence. I looked at the evidence that was in that rulemaking back in 2015 when I was still, practicing as an engineer. And obviously we studied it at Purdue. I tend to think that it's not real, that there is not evidence, or at least we have fairly good data now at low doses, right? We've been giving people CAT scans for a very long time. We have tracked people who live in Denver and people who live at sea level, which changes how much of low doses you're getting at rates that exceed what you get from working in a nuclear power plant, at least at a PWR. BWRs, they get a little bit more. But it is a little bit absurd to me, and I think one thing that I don't know if the NRC has caught on to this yet or not, or if it's still happening, but I witnessed it in industry. I heard others who witnessed it in industry tell me the same thing. It leads to some bad behavior in the attempt to comply with these extraordinarily low doses. The classic example is, we had our dosimeters at the plant. We had the one that you couldn't read. I forget what they called it, but it was always sitting on your lanyard.
Yeah, the thermoluminescent dosimeter, TLD.
The TLD. The TLD was always on your lanyard. You never took it off. You turned it in every 6 months or a year, whatever it was. I think it was 6 months. And it got read, and then it went in your personal file that you never saw unless you requested it. And it kept track of your lifetime dose. So that didn't change, right? There's not a way to game that system. But in the interim, while you're waiting for those 6 months to come up, you have your little readable dosimeter that you wear into the radioactive controlled areas, right? That actually says, and that goes down to the 10th of a millirem, but it rounds to the nearest full millirem. So what people did was they would say, all right, the target for this job, which historically has been a 12 millirem job collectively across, 4 people, right? 3 millirem each. Who cares, right? But we need to game the system. We need to go for 0, right? Because the industry standard now is 0. Others have shown that 0 is achievable. We need to be able to report 0 because that's what the NRC wants to see. That's what INPO wants to see. We're doing everything we can. So they'd have 2 teams. And when the first person on a team got to 0.4, they'd pull them from the field and put in the next team. So now you're traversing, right? You walk out into the plant. Maybe it's a 10-minute walk through, various parts of the plant that have tripping hazards, that have high heat, that have all this stuff. You're increasing the possibility of an industrial accident in between there by marching teams in and out. You have teams that are just kind of getting into a groove and you're pulling them out right when they figure out what's going on and putting in a fresh team that hasn't been doing it.
Surely that fresh random guy will know exactly which part of the nut to turn at this point.
Right.
Yeah, you're just that much more of a bad installation risk, right?
Right. You're have more collective time in this heat because you have to count for the traversing time and passing off to people and they're walking in and out. And you're increasing the total number of people who are exposed to some amount of radiation, which if you believe LNT matters, right? And all to not even save any total collective REM, but to create the appearance that you achieved 0 collective REM. And this was happening everywhere. If you didn't have this theory underpinning the regulations that there's not strong evidence for, then, people wouldn't be incentivized to behave that way. So that's just, one very clear example, but that was one that always got on my nerves. That was always, a personal pet peeve of mine. And now that I've said all that, I feel like I have to once again make clear that my opinions are not the opinions of my employer or my clients.
Yeah,
they love everything that the NRC does, and so do I. Like I said before, they're very reasonable people. They're committed to their jobs. So anyway, that's my story.
Yeah, no, it's a great story, and I think that brings me to a point that I think we inferred earlier. But if you don't have a technical lawyer like Andy on your team, you need to get him on retainer as soon as possible, or one of the few other unicorns like him. Yeah, because here's another thing is that, your company can have a lot of great engineers. Your company can have a lot of great regulatory affairs specialists. But usually at the end of the day, the investors, they want a lawyer making the calls. They want a lawyer involved in every big decision. And frankly, if you've got a lawyer that is either not technical or is technical but not nuclear technical, they don't have a good gauge of what is reasonable and what is not. And I've seen it so many times where a lawyer just reverts to interpreting the most conservative, risk-averse position that he can out of the words, and that's just what he does for everything. And it can really constipate the whole process. Let's say, as I said earlier, if you can find one of those unicorn nuclear tech savvy lawyers, you really need one on your team today. So
well, thank you.
Yeah, and that's because the lawyer gets involved not only in major, legal lawsuit sorts of stuff, but, they're reviewing all the contracts. And yeah, I'd say that in my time setting up supply chains for a couple different vendors and, the actual people that we ended up signing agreements with, and then all the other vendors that we flirted with and how to get NDAs in place and all these things, it really shows a lot on your company, whether that interfacing lawyer is with it or not. So I think one last thing to do is to pull up 10 CFR 50.3. If you read 50.3, you'll see all these caveats, but practically speaking, everyone looks to the OGC for the interpretation. So, if you had one friend at the NRC that you could buy a pizza for, send it to the OGC person because they are the decision makers. And as it says here, except as specifically authorized by the Commission in writing, no interpretation of the meaning of the regulations in this part by any officer or employee of the Commission, other than a written interpretation by the General Counsel, will be recognized as binding upon the Commission. And this is just 10 CFR 50, but there's similar blurbs elsewhere throughout 10 CFR.
Yeah, and that's more just a CYA from the NRC to make sure if some low-level employee says something off the cuff, you're just, talking to the inspector or, a licensing engineer or whoever, and you say, I think this means this, and they go, well, that sounds right off the top of my head. And then you act on it, and the Commission disagrees. You can't stake out a litigation position on that off the cuff remark. But in my experience, the staff that I've worked with, inspectors, etc., they're well trained on this as well. If you have an issue, for example, one thing that comes up a lot outside of the power industry, so maybe not the perfect example, but companies all over the place, right, that have nothing to do with nuclear, bottling companies, construction companies, they need these materials permits because they have a gauge that uses a source in it or whatever. When they're bought and sold, the NRC needs to give advance approval of transferring their licenses. Very frequently, they're not even thinking about that. No one else requires that. Every other environmental permit requires just an after-the-fact notification that the licensee changed, is bought, change of control, whatever. And they oftentimes don't get the right lawyer involved until it's too late, until the transfer of ownership has happened. Or the transfer of ownership is imminent. There are signed agreements they can't get out of, but technically it hasn't happened yet, but there's not enough time for the commission to review. That's where I've spent a lot of my enforcement time because these cases are just so frequent. I have found that where I need an interpretation, where I need someone to say, hey, maybe we can get some language in this contract that will allow the change of ownership to go through, but you're comfortable that they're still meeting all of the requirements until the NRC approval is given. They always run it up the chain. They always go get an answer from OGC. No one's ever just tried to agree to language or give me an off-the-cuff answer, right? They run it up to OGC. They say, I tell them what I want to do to get them comfortable. They take it to OGC. OGC either approves it or says, absolutely not, depending on the circumstances, and you live with it.
In the exact same way that the OGC is everyone's safety blanket at the NRC, whether you're the librarian or the commissioner, everyone wants to go to OGC as the safety blanket at most firms too, right? Like the lawyer is the safety blanket that all the executives and all the hiring managers and everyone wants to make sure the lawyer is cool with it. And so, like in the same way that OGC has this really large amount of sway, the company lawyer has a large amount of sway and a big impact. The right one deserves to get what he gets. Man, if I had $1 for every time that I got out of like an NRC pre-app meeting or I heard someone describe their interaction with the NRC, usually at a pre-app meeting, they'll say, we've got this novel thing that we proposed to the NRC and, none of them pushed back on it and said that it was totally forbidden. So they're totally cool with it. And so we're just going to run with this. We've already talked to the NRC. They didn't say anything about it. We're going with this. And it's just well, no, the NRC didn't actually give you an opinion just by being quiet at a pre-app meeting. Who even knows if the right staff was there? Could have just been the intern nodding his head there.
Silence is not consent. Period. End of story.
Excellent. Yeah, I think one other thing is the statements of consideration.
Do you know what the NRC's statements of consideration are? Most nuclear professionals that should know don't know, and it's holding us all back. Statements of consideration are the key to unlocking your understanding of the NRC's rules and regulations. Join my nuclear lawyer friend Andrew.Kriha and I as we teach you how to find and how to use NRC's statements of consideration. You'll get a leg up on your peers who may only know about regulatory guides and 10 CFR itself. Get better at your job, make more money, and register for free at nucleartalentboost.com today.
There are just so many technical nuances that someone without your background just can't see and can't take advantage of, and it's just really such a rarity. Usually a trader like yourself who's gone from engineering to the legal team, it's they almost always choose to be a patent lawyer, right? Or something like that, because the patents are technical, right? But there's lots of technical stuff going on, especially at these advanced reactor firms with their legal counsels. And it's almost priceless to have a technical lawyer, especially an actual nuclear engineering technical lawyer. The only other person like you that I can think of was a guy at NuScale. It's one legendary story about him. There was one time when, there was some proprietary issue I can't talk about, but there was a bunch of disagreements about what to do. And there's this engineer, right, who's been an engineer for 30 years. Before he came to NuScale, he worked at one plant. And he comes into the conversation and says, hey, we have to do it this way because, I'm an actual engineer and this is a technical issue, and my plant did it this way. This must be the nuclear way of doing things. We have to do it this way, right? What's this stupid lawyer? Like, he was like being condescending to NuScale's lawyer. And then, NuScale's amazing technical lawyer, he comes in and says, well, engineer guy who's worked at the same plant for 30 years, I can tell you that there are 3 other plants in the fleet that do it the way that I just proposed. And, there's even this third way that we could do it that would essentially be this, $1 million of savings. And all the laws and regulations point to this third way is allowable. Then he went on to talk about, all these different aspects of these different reactor designs and why the case applies to NuScale in light of these 3 other reactor designs. And, that one guy with his 1 reactor's worth of experience just slowly sulked out of the room with his tail behind his legs, and it was just a really glorious moment. The moral of the story is that a technical lawyer can really pull you out of a bind, and yay, Andy.
I mean, look, I think it is very valuable to have, in general, in life, whether it's nuclear plus law, whatever, I think it's great to have 2 different areas of expertise that you can draw upon to always challenge yourself as to whether or not you're looking at it from the right angle, from different perspectives, and give that view. But you kind of make out the engineer is not necessarily the best guy in that situation, but I'll tell you, man, it is easy working in the nuclear industry in such a regimented, procedure-driven industry to fall into that mindset of this is how it's done without thinking critically about why it's done. And when I worked there, man, we had meetings right at the top of meetings almost every day reminding us to not fall into that mindset because it's so easy. You still had to put effort into not falling into that mindset. It's both the blessing and the curse of the industry, right? They've figured out what works for specific plants, and they've memorialized that in easy to follow procedures that are very hard to screw up. Doesn't mean people don't screw them up. Stories I can't tell while we're recording, but it is very hard to lose sight of that and think critically sometimes.
Yeah, I think that's really the glory of working in the advanced nuclear space and just the new design space in general. Well, I mean, first, the obvious glory that you don't have to work outages, right? But B, yeah, you get to do all this critical thinking and really think about why do operating plants do it like this? Do we have to do it like that here? And I think that the way that you described your journey of getting burnt out on not getting to do enough creative thinking and stuff, Andy, I think you were just always meant for the advanced reactor industry. You would have thrived as an engineer here.
Well, now I can be an advanced reactor lawyer and still talk to the engineers and talk through problems with them, and it's just as fun from a slightly different angle.
Andy, you've been a fantastic guest, but this isn't a coincidence. You've got your own podcast and everything called
An Energized Exchange.
I really enjoy it. Tell the audience more about it.
Yeah, so first of all, and this is something I even need to get through with some people at my own firm. It is not my podcast. This is a podcast put out by the law firm that I work for, Holland & Knight. None of the views I've expressed here are views of the firm. Just got to throw that out there. But it's put out by the firm that I work for. I have utilized that platform far more than anybody else. And so some people even in the firm have started to think of it as my podcast. I don't want it to be that way. We have a lot of great, extraordinarily smart people who have a lot to say and should be using it to say more. But it is a podcast put out by all of the attorneys in our group that do anything related to environment, energy, climate, or natural resources. And we just kind of talk about the topics of the day. I have not done an episode specifically on nuclear yet. As you said, I work with a lot of other agencies as well, EPA, particularly in the transportation fuel side. So I've put out 3 or 4 episodes there. I do a lot of work with voluntary carbon offsets and carbon markets. Generally, I have an episode on that and put one out on greenwashing mitigation, particularly in the context of the non-delegation doctrine, which I talked about a little earlier. We also have, an episode on FERC and the FERC transmission rule, and are going to be continuing to put out content going forward. I assume there will be some Chevron-related episodes coming out as we expand and formalize our nuclear team, because we do a lot of great nuclear work. It just hasn't been as formally marketed in the past, so we're going to start to put out some of that content and content, more specific to your audience as well. But it's great. It's very legal focused. We try to make it as focused toward what the commercial folks need to know as much as possible. I think it's great. I think you should give it a listen.
Yeah, and I would say that, I was a licensing engineer for 5 years. And so like, to me, listening to like, oh, what's this circuit going to do? And like, what if this lawyer says this? What's the Supreme Court going to make of this? All these things are right up my alley. And I think that there's plenty of other licensing engineers listening as well. So Andy, we like went to school together at Purdue. You were a reactor engineer for a while, and then you just decided to become a lawyer, huh? What's the deal with that?
Yeah, I don't know if you recall, but back when we were at Purdue through ANS, I was kind of involved in a little bit of more the political advocacy side of nuclear, ANS's outreach program. We had a group that was put together by our senator at the time, Richard Lugar, for college energy groups to interface with each other and kind of advise on policy stuff, and I was pretty involved in that. And so when I was working as an engineer, I did not find the job as exciting as I did in college. There were a lot more routine monthly jobs that were done, just by procedure that you had to kind of mindlessly follow, and a lot fewer true engineering, engage your mind aspects. And then, of course, nuclear was going through some tough times, right?
We graduated the year after Fukushima.
Right, exactly. And so then there was all of these additional costs placed on the industry as a part of responding to Fukushima. It became less competitive. Natural gas was really cheap, right? So the whole industry was going under this process that they called delivering the nuclear promise, where they were going to cut a bunch of jobs and stuff and streamline processes. And it was kind of one of those things, like I didn't know exactly what the future was there within traditional nuclear, and I kind of had this old interest that I wanted to go back to. I looked at going into policy first, right? Maybe doing some advocacy stuff like I'd been engaged in college, and realized that was not my personality. I'm an introvert. I want to sit in an office and do analysis. I don't want to be out shaking hands, kissing babies, doing all of that networking stuff. So thought law was maybe a little better than policy, and here we are.
Yeah, because when we graduated right after Fukushima, we were both pretty good students near the top of the class. My top job offer coming out of college was in the hardest degree, right? Nuclear engineering, you have to take everyone else's weed out classes in addition to your own harder ones, quantum mechanics and all that junk. And then after all of that, like my top offer was an internship at NuScale. And then I was just like, hey, man, this is an advanced reactor. I'm not going to get paid much as an intern, but like, hey, this is exactly what I always dreamed to do, man. Be the Henry Ford of nuclear, making all these modular reactors.
Yeah, I mean, so I had co-opted, so I ended up graduating a year later than the rest of you. Well, I took that year to work at Dominion. And so with the class that I actually graduated with, roughly half went to grad school, but of the other half who were looking for jobs, I think it was only me and Nick, who had both co-opted with Dominion, that had jobs at the time of graduation. It took everyone else a while to find things after, and several, ended up in more mechanical roles rather than nuclear, because the industry was hurting at that time. Yeah.
Yeah, but luckily the nuclear promise is here, the real nuclear promise. I speak with a lot of my friends, old mentors who, lived through TMI and all these sorts of things and worked there during it, spent their whole careers in nuclear. And they're all saying, like, today, of all the days in the world, nuclear's just never been more optimistic. No one's been investing more bullishly into it. And yeah, there's just a whole lot of hope. And there's all of these new laws and stuff being passed, all these new Supreme Court decisions. It's just amazing, right?
Right. I mean, we just got the Advance Act about 2 weeks ago or so, and that is probably the most overwhelmingly bipartisan bill to be passed in years. Nuclear has a lot going for it, right? It's attractive on the left. The environmentalists have finally started to come around to seeing its low carbon promise and realize that maybe some of the safety concerns have been overblown. It's had a very strong safety record. The waste issue is still out there. Various advanced reactors solve that better than some others. Policy could still advance quite a bit in allaying those concerns, but it's that climate impact has started to outweigh some of those other concerns for that side. And then, of course, on the right, there's this whole energy security streak going through that side of the political aisle, right? And nuclear is great for that. We can be pretty independent and provide good baseload electricity. It doesn't have some of the problems. I'm an all of the above guy. Still love my wind and my solar, but you need baseload, right? It's one of the things that we can all pretty much agree on.
Yeah, I would personally chide you. I'm an all nuclear guy, and I can't imagine why anyone would ever tolerate a windmill killing all the bats and birds and whatever. But
I like a good, diverse portfolio, Russell. As much as I love nuclear, you don't want all your eggs in one basket. You don't want a single point vulnerability. The uranium supply chain could be disrupted, the enrichment supply. I mean, that's kind of our biggest weakness right now, right? We don't have the, enrichment and fabrication supply chain fully onshored. It doesn't hurt to have other things out there, other things that can help. And you look, some of these, right? There's like, Oklo, for example, there's these companies that can extend the lifespan of their reactor by slapping some solar panels on the top of it and load following the solar panels. So nothing wrong with that.
all right, you've offered your pinch of incense to the energy gods. Spent so many days studying in Purdue's library, and look at where it got me, into a little small dorm room looking thing in DC.
I mean, to be fair, I have a very nice condo outside of this room. This little room, 10 feet by 12 feet. It's got a Murphy bed. It's got my home gym.
Andy, come back to the land of milk and cheese. You could get like a mansion for what you're paying for that little pull-out bed apartment.
It's interesting to think about. If Dominion had never shut down Kewaunee, would I still be an engineer in Kewaunee, Wisconsin? Living in a Lake Michigan waterfront mansion that's half the price of this condo? Maybe. Who knows? Probably not. The same things that applied at Surrey would have applied at Kewaunee as well, but you never know. The things that happen, right, that are out of your control.
Indeed. We'll let Providence guide, I suppose.
Wisconsin's really starting to become like a bit of a hub for nuclear. I mean, it always was with like Kewaunee and being that close to Chicago and stuff, but now University of Wisconsin has like all these advanced reactor test labs. They just had that fusion breakthrough, and then there's Shine in beautiful Janesville, Wisconsin too, doing a whole bunch of great work. So why did you leave Wisconsin and decide to take residence in a dorm room in DC?
Well, I did not decide to leave Wisconsin. Dominion decided I would leave Wisconsin. And I co-opted Kewaunee all through my time at Purdue, and they announced it was for sale for most of that time, and they couldn't find a buyer. And so they announced October of my senior year that they were going to shut it down, and then it actually shut down like 2 days before I graduated or something like that.
No.
So they moved me out to Virginia, and they moved me out to Surrey. I did do some interviews in the Midwest still. I had an offer that I strongly considered for Dresden, I think, one of the Exelon plants in Illinois, but decided to stick with it, decided to try something new. I'd lived in Wisconsin or Indiana for my entire life, and so I did that full-time out there for a little over 4 years, and then just when I went to law school, stayed, got that in-state tuition at UVA. I had a life out there, so I stayed. And I kind of knew, I wanted to do DC for work. I wanted to do regulatory. I wanted to do EPA work. I wanted to do NRC work. And DC's really the place to do that.
Well, I'm glad that you've kept a little bit of the Wisconsin accent. Sometimes I see my daughters picking up the Wisconsin accent, and I'm just like, oh no.
Well, you just had, the way you just said, oh no there, you had a little bit of it yourself. So
yeah, no, it's, my life's becoming like a Charlie Barron skit.
Ah, man.
Follow that comedian.
Oh, yeah.
One Purdue thing to talk about. Did you see that Dr. Elan is just like the kingmaker in fusion now? He just became the guy that gets to hand out all of the DOE's fusion money, or like decide who gets it. I don't know. That was my impression of it. With as much money as is being thrown out at fusion. Yeah, I just thought it's sort of neat that guy was teaching us at Purdue, and I thought he was one of the best professors there. I mean, he actually spent a lot of time with us, right?
Yeah, I think he was one of my group's advisors for our senior design project. It's all coming back to me now. But he was fantastic. Some of my best friends stayed on to do grad school with him. Now are off in great careers at startups in Los Alamos and all over the place. Yeah. Wow, man, I hadn't thought of that dude in a long time.
Right. I mean, I took like all of his classes, all of his like grad classes and stuff for whatever reason. Yeah, it actually was very surprising to me. I did a little bit of grad school at Oregon State University, working in a thermal hydraulics lab on like a DOE grant scholarship thingerbob. Get paid to go to school gig, which is sweet. Yeah, thanks to Dr. Wu and Kent Welter for helping set me up with that. Yeah, it was very surprising to me the different curriculum that different nuclear engineering schools were giving. It seemed that no one there really knew much about materials. Like materials engineering and metallurgy and stuff just didn't seem to be a focus of their curriculum. Lots of people I talked to just didn't know what like a DPA meant.
And that was a huge part of what we did.
Yeah, it's almost all we did. Like we took like it seems like we took 3 semesters where we just talked about the Kinchin-Pease model like in depth and like different metallurgy labs and stuff. But conversely, at Purdue, I don't remember taking a single class or it even being mentioned like numerical analysis and sort of how do computers estimate numbers, right? With like the Euler method or like the Lagrange-Kutta method or all these other things of like, how does relap 5 actually like do its calculations, or any calculator? How does it like actually do the math, so that you can exploit that? Like the equivalent of what we did at materials, like they did in numerical analysis and like getting to play with relap 5 and MCNP and other things.
Yeah, I mean, that's, we could have a whole philosophical discussion about universities and the tenure system and all of that, but it's really built on who you hire, right? And they're going to teach what they want to teach because that's what they want to teach and they're tenured.
Yeah, all the undergrads are just going to be experts in whatever this guy's researching.
Yeah. Good times.
Andy, do you have any closing statements for the audience?
No.
Cool.
I'd say the main lesson to take away here is, particularly if you're an engineer, right, you have obligations. They're defined by law. They're defined by the NRC. There are people in your organization that can help you navigate it. You don't have to do it alone. It's truly a team effort, right? There are people who are specialized in knowing how the NRC is going to react to certain things. You as an engineer, the technical expert, working together, understanding each other, knowing enough about each other's space to be dangerous is a good thing. Also knowing that you only know enough to be dangerous is also a very good thing. So there's your lesson.
Excellent. Yeah, thanks a lot for being a guest on our show today, Andy. And if people are just enamored with how attractive and smart you are and want to get a hold of you, how do they reach you?
They can reach me by email at Andrew.Kriha@hklaw.com. Search for Andrew.Kriha, and my phone number is on my work bio. There's a whole biography with my picture and everything. And you can listen to my podcast, An Energized Exchange, put out by Holland and Knight and available on most major podcast platforms.
And they can reach you on LinkedIn.
Oh, yeah, LinkedIn too. That's how Russell and I reconnected. So yeah, LinkedIn, Andy.Kriha, Kriha.
We hope you enjoyed the show. We're helping solve the energy crisis for our children and the world by addressing the nuclear talent shortage. Please help us by liking, sharing, and subscribing, registering on nucleartalentboost.com, and telling your human resources and procurement departments you'd like to work with nucleartalentscout.com for all your staffing needs.